Terrific.
Welcome and thank you to those who have joined us live and to those listening to the delayed broadcast of the Independent Trustee Alliance webinar series. Today's topic is Essentials of Trustee Liability Insurance with Judith Pearson of Nomadx Solutions. My name is Kevin Quinn. I'm the president of the Independent Trustee Alliance and the moderator for this session. Please hold questions or type them in the chat box so they can be addressed at the end of the presentation. And most importantly, please mute your line. The ITA is a professional association formed by trustees, personal fiduciaries, and other family consultants who work independently or for family offices. We believe the independent trustee is a rising profession, though one that leaves many people asking, what is an independent trustee? What is a personal fiduciary? And how can I be assured you know what you're doing? Thus, the objective of the Independent Trustee Alliance is to raise awareness of the profession of independent trustee through marketing, continuing education, workshops, and conferences. We will shape the future by educating, training, and certifying the professionals of today and tomorrow, as well as family members and even beneficiaries. One day, advisors will say to their client, you need an independent trustee, and that trustee needs to be ITA certified. Membership in the Alliance is open to anyone who supports the concept. Join us for the ITA Annual Conference May 16th to 17th in Dallas, Texas. For more information, please visit trusteealliance.com. And as we begin, a reminder, information presented in this webinar is not to be construed as legal advice. Judith is an expert in the field of risk management and focuses now exclusively on providing fiduciaries with resources necessary to identify, mitigate, and transfer the risk inherent with their position. Judith, you have the floor.
Thank you, Kevin, and I appreciate everybody who's joining us today. And I want to start up front by saying I think the work that the ITA and its members are doing is really critical for the field, and I'm really grateful to be a part of this. Today I will be discussing who is serving as a trustee, what to consider as a trustee, how to protect trustees, and then I'll get into the insurance program, which will include how to read a policy and specific coverage enhancements. As I go through these slides, some of the things in the beginning I know you know from your own business, but I want to put it in context of the insurance program that we are building. So the first thing is, who do we see serving as trustees? You know, it's been a long-term tradition for the wealth creators and the grantors to choose friends and family, and more frequently now professional trustees. A fairly traditional situation that we've seen. Also, we've seen 25% at least choosing corporate trustees, but that is really changing, and we see a lot of clients opting out of the corporate trustee model unless they are going to a directed trust model. What I see more interesting is we're starting to see professionals wanting to become the most trusted advisor. So we're seeing more law firms allowing their attorneys to serve as trustee. We're seeing more CPAs as they create private client divisions within an organization or acquiring RIAs to also agree to be trustee, as well as financial advisors as they're changing their business model. What that means is the education that ITA is doing and others are trying to accomplish is going to be critical in order for us to protect the trustee, because oftentimes the skill set the individual had to become that trusted advisor is a different skill set that's needed to be the trustee acting as a fiduciary on behalf of the beneficiary. Kevin, can you switch slides? One of the things that's often not understood when an individual first accepts the role as a trustee is that if you are a fiduciary, you face risk, and that risk can become personal liability. And in the face of litigation, that can be oftentimes very expensive, very scary. And one of the biggest challenges that we see is the trustee doesn't always know what kind of lawyer to go to get the best defense. And so as we start going through this presentation, I want you to start thinking about insurance not just being a financial opportunity for you, but it's a service, because it will give you access to the best defense counsel and save you from having to look around and potentially make a mistake. Kevin, can you switch? So some of the things that you should consider before you become a trustee, again, I know most of you have thought about these things, but at the moment, you may not always ask all of the right questions. First of all, it's so important to read the trust document and find out what's expected, because this world, as you know, is changing so fast and furiously. None of the documents are the same. You may think that you understand some of the roles, but when you have to overlap it with what's going on the state level, federal level, and international level, there may be some gaps that you might not have thought of. The next thing is to ensure that you have the skills and resources needed to do the job. One of the best risk management techniques is to make sure that as a professional fiduciary that you are either hiring or delegating or consulting with some of the professionals, such as if you're working as a trustee to a traditional trust, the right investment advisors. If you're not a CPA, making sure that you have somebody who really understands the accounting. If you're not a lawyer, make sure that you have somebody that you can rely on to ask questions about how to do something if something very complicated comes up. It's also really important to think through what potential conflicts of interest you might have accepting the responsibility. And I know that on the front side, it seems like that's a really easy question. But I've had a couple of clients recently say to me that they really didn't anticipate almost emotional conflicts when they were so used to protecting the settlor. And as the settlor would talk about the relationship he had with some of the beneficiaries, and they kind of got shifted to one way about feeling about how they feel about a certain beneficiary. And when they became the actual trustee and fiduciary, they kind of had to rejig their mind so that they could be very objective when dealing with requests from the beneficiary. So I think it's something that's really important to think through. Also, how time-consuming this job is. I often have people come to me and say, I thought that it would be fairly easy, but it's so very time-consuming. I want to make sure that I can do the job appropriately. And then finally, you really should look at the documents to make sure that you're protected if you take on that role. One of the things I've been seeing across the country, I would say about 80% of the trusts that I see don't have an indemnification provision in them. Now, sometimes the trusts were written to rely on a state law, and other times everybody was focused on other issues and didn't think about the indemnification agreement. And that is a very important aspect in the face of litigation. The other side of it is it's very important to make sure that the trust assets can be used to purchase insurance, and if not, put together a fee arrangement so that perhaps you can get the trust to pay for the insurance in a different way, which becomes a deductible expense. Next slide, please. The next couple of slides, I just want to get you thinking about some of the things that I've been seeing and the expertise that you might want to have. So the first thing is know your assets. It's pretty easy if you have a trust that has traditional assets such as stocks and bonds. It's even relatively easy if you have an ILIT. But as some of you who have been following the life insurance blogs, so to speak, know that there are a lot of issues around the ILITs today, that perhaps they were sold in one way or anticipated a certain return or anticipated a life expectancy that's shorter than is expected today. And all those things can create challenges in the life insurance trust. And I've had many people come to me and explain that they were very surprised about the challenges, and it became very complicated on how to fix it. Art and collectibles are something that really should be focused on. I have seen a lot of different things, such as it's said in the trust when somebody passes away that some of the art and collectibles are going to go to a museum, only to find that the museum doesn't want the object. So some of those things you should ask questions ahead of time. I also recently had a situation where it was a law firm that had a trust company on the East Coast who had one estate that had one very valuable work of art at the time of death of a settler. They went to one of the auction houses to get an appraiser in order to close out an appraisal in order to close out the estate. That appraisal came back at $2.5 million. It then went to, they filed the return and it went in front of the art panel, and the art panel said, I'm sorry, but that valuation really should have been $7.5 million, and you owe taxes, fines, and penalties on an additional $5 million. I immediately recommended 2 appraisers that I know that really can go toe-to-toe with the IRS. And the idea was, if they could get the right appraisal, they could either negotiate with the IRS right away or find out that they didn't really have a problem. And it turned out that it was somewhere in between, and they were able to settle it very quickly. My point being is, once you start getting into alternative asset classes, you really need to understand those assets. And finally, when you have family-owned businesses or ranch or farm properties, that can get really complicated. And so just make sure that you have that expertise if you're taking on that kind of a trust. Next slide, please. I always like this. Know your trustees, your co-trustees. You know, he has control of my assets. And, you know, we all know the scenarios about what can happen if you have uneducated, or if not uneducated, they just don't necessarily know the roles and responsibilities around being a co-trustee, or there are conflicts, and we see lots of litigation over that. We know that. Next slide, please. Know your beneficiaries. Love this slide. Daddy omitted me from his will. Luckily, that just means I can attack it as a mistake. And I've got a number of situations going on with that kind of litigation. I just think it's important that people really understand who the beneficiaries are going to be, independent from the settlor, because the settlor often, as we know, underestimates the relationship between the children. Next slide, please. So back to protecting the trustee. We really look at both how is the law operating versus how can you manage through the insurance. And they're really interconnected, because the more mitigation we can put into the trust from a structural perspective, meaning indemnification agreements and process and procedure, and being very clear what are the roles and responsibilities and what are the intent, the less likelihood there is going to be of litigation. We also encourage education of the beneficiaries, because lots of the litigation comes from beneficiaries not really understanding the role of the trust, the role of the trustee, and how to hold that trustee accountable in a positive way. And we believe that if we can educate both sides, that we can reduce friction and therefore litigation. And then the more we can reduce that, we can do a better job on the insurance piece. And so we look at it as a whole package of first looking at what the risk is, which is different by every trust, and different whether it's a traditional trust, a delegated trust, or a directed trust. And by the time we get to a directed trust, it can be very complex on what the risk looks like. We talked about risk mitigation, and depending on what type of trust we're looking at, the mitigation is different. And then once we go through those steps, that's when we like to look at the insurance piece. Next slide. So the directors of and the founders of ITA, in particular, Kevin was leading the charge, thought that if we could get a really good policy from both a coverage perspective and a pricing perspective for the ITA, that would be a really good benefit for the members. And because the members are going to be certified and are going to be educated and are going to be screened, we were able to go to underwriters and start working through a program. So we currently have a program. We have 3 different pricing tiers. You can apply online through a link only available to ITA members. And the policy that's been negotiated is very broad. The point that I really want to make before, well, you can go to the next slide and then I'll start making it, is what's the difference between the tier 1 and the tier 2, and what are we trying to accomplish? So the first thing I want to mention is we were able to find an underwriter who is willing to believe in the association, but without any data, it was really difficult to get somebody to commit to pricing and a policy until we had volume. And the underwriter that we were able to identify is part of a very large company called Berkeley. And we came out with some tiers to start with. So tier 1 would be the insured's an independent trustee, manages fewer than 5 trusts with a total estimated assets of less than $20 million. I know already everybody's saying things like, well, what happens if we have 1 master trust and there's 20 sub-trusts, right? So those are all the things that when we get a submission in, it's my job to go to the underwriter and say, it looks like it's not really in tier 1, but it is because of XYZ. And if I can also be looking at it and saying, it looks like it's not, it is in tier 1, but it's really not because of XYZ. And the whole idea is to try and really help the underwriter understand how to price the risk and provide the right coverage. And the more volume we have, the more we can fine tune things. So tier 1 pricing, if you qualify, has a deductible of $2,500 and a premium of $1,500 per year plus surplus lines tax. And surplus lines tax is a minimal price that's required by state. Tier 2 would be an independent trustee that has fewer than 20 trusts and less than 50 million in assets. And the other requirements for that, I think it's on the next page if you want to go to the next slide. Yes. The other requirements is, does the trustee have discretionary authority over the trust managed? Well, if it's a traditional trust, we already know that you have discretionary authority. Through submissions that I've already provided to the underwriter, I've been able to get them to understand that if it's very clear that an investment advisor has been hired to make those decisions, we can often get that trust back into a tier 1 pricing. We've already talked about the way, how many trusts are managed. And so I've already had a couple that had, only 2 master trusts, but lots of sub-trusts. And I was able to get that into the tier 1 pricing because they're relatively small. The next one has been kind of tricky, the trustee being a beneficiary of a trust. The underwriters believe, and I would agree, that if you have a trustee who is a family member and therefore also a beneficiary, meaning one of the siblings is the trustee, that could potentially create problems or increased exposure, and they want to charge more for the risk. I've been able to, on a couple of occasions, show that in particular situations that might not be the right way of underwriting it. And so it all depends on what the trust looks like, and the more information you can give me around an exposure like that, the better I can work with an underwriter. Obviously, if there have been claims, that's going to be a different pricing structure. And if there are alternative asset classes, we have to explain to the underwriter what those are, what the expertise is, and we'll see as those kinds of trusts come around. But so far, I haven't seen too many that have had the alternative asset classes of more than 10% of the trust assets. So I'll be able to give you an update of that later on. Next slide, please. One of the things that, as Kevin and I were talking about this presentation, it occurred to us that it might be helpful for you to understand how I read a policy. So when one of you sends me a submission and I ask for your current policy, here's what I'm looking at. The first thing is the insuring agreement. And most notable, what I look at for that is whether the underwriter is going to pay on behalf of your litigation fees, or if they're going to wait to reimburse costs at the end of litigation. The next thing I look at is definitions, because this is where we start seeing, the fine print get in the way. So the first thing is, what are the definitions of trustee? And I have seen all sorts of definitions, some of which use language that I've never seen in a trust document. So the more we can standardize what the definition of a trustee is and what the services you're providing are, the better we can provide the coverage. I think we've got a really good definition in what's been negotiated, and some of the things that we've had to manage through are, I've seen exclusions for distribution and exclusions for investment, and we've been able to get those removed if we have, again, hiring all the right professionals and explaining to the underwriters that that's one of the jobs of a trustee, and so we've been able to broaden coverage. The next thing is the exclusions, and I see all sorts of exclusions being built into some of these policies, so we're very careful to get rid of the exclusions that on a normal basis would affect coverage. Finally, endorsements, because endorsements change the base of the policy. So you may have the definition of trustee look one way in the policy itself, and then it fundamentally gets changed by endorsement. And so it's really critical to then make sure nothing significant has been changed by endorsement. Settlements and defense, that's again a fine-tuning on when do you get your costs, are they given to you in advance? Is it at the end of the policy term? Will they hold back expenses if something has been alleged, where other policies might provide defense up until final adjudication, meaning if there's a settlement without admitting liability, you might still have coverage. So there's a lot of fine tuning in there. And then the general conditions, which get into when do you report, how do you report a claim, that can get very complicated if something happens right at the end of a policy period. Next slide, please. So these are some of the things that we've been able to get broadened in this policy, some of which I've already kind of talked about. The definition of professional services, I believe, is very broad, but if you make a submission to us and we get a proposal, it's one of the things I'm going to want to work with you in case there's something that's unusual in your services that we need to address. The pay on behalf of language versus reimbursement, key, because I don't think anybody wants to wait until the end of litigation to get some costs advanced. Defense until final adjudication, that is really important because otherwise you might receive what's called a reservation of rights letter that says we're not going to defend until we see what happens at the end. Couple of exclusions that we've been able to amend: emotional distress and mental anguish. You know, that could be something that a beneficiary alleges in a claim. So we've been able to get a $100,000 sublimit. One that I find really interesting is every single policy I've seen up until now has a failure to procure, affect, or maintain insurance. And as I've explained to the underwriter, especially if you're handling real estate or other business assets and you're the trustee and it's your responsibility to make sure those assets are protected, it's probably your responsibility to get insurance as well. So we've been able to get that exclusion deleted. Coverage for disciplinary actions and subpoenas. Another one, co-defendant coverage when rendering professional services on behalf of the named insured. What that means is if you are a trustee and you hire an accountant and the accountant gets sued and you get sued as a co-defendant, we can get you defense costs while we're going through that litigation. And finally, we have minimal coverage, but a sublimit for cyber liability. It's a $25,000 sublimit and has some coverage. While we do have some coverage, I really encourage everybody to think about getting a separate cyber liability policy. They're not very expensive for a trustee. We've been able to get them somewhere between $500 and $1,000. But boy, if there's a breach, there could be so much liability. It would be much better to have a real policy than the sublimit, but at least we do have a sublimit. I also want to make sure everybody sees in red that these are kind of general conversations until we see a specific proposal. And so each proposal, even though we've pre-negotiated rates and policy provisions, I still want you to make sure you read the entire policy. And if you have any questions, to ask us about it, because that is what's going to dictate a claim. Next, I think just offers, are there, questions that you guys have? Are there issues you want to talk about? And again, I want to finally emphasize the fact that this is a start of a program. And the more volume we can give the underwriter, the better we can fine tune these tiers, the better we can fine tune the pricing, and the better we can fine tune the coverage. And I really appreciate you working with us and having the confidence that we can do the best job possible on your behalf. And I think that's my 30 minutes, Kevin.
All right, thank you, Judith. If anybody has a question at the moment that you'd like to ask Judy, just come on, unmute yourself and ask, or type it into the chat box. Richard, did you have a question?
Yes. Hey, Kevin. Hey, Judy. Everybody else on the call. My question about the trustee being a beneficiary, does that relate to trustees of current trust or contingent trusts, contingent beneficiaries, or both? Both the current, is it current beneficiary or contingent beneficiary, or both?
So great question. And we've had a situation, and I don't know how far you want to go into this, where there's a potential contingent situation, and we've gone to the underwriter to explain that that shouldn't be an issue. So that's the kind of thing that is very helpful if we have trust documents and can understand the situation and be able to go to the underwriter to say, this doesn't really apply because of X, Y, and Z.
Okay. Peter May had a question of what's the best way to jumpstart this conversation for the uninformed?
That's a great question, Peter. Thank you. And it's really when you're talking with the people that are helping create the trust and helping the wealth creator choose the trustees and the trustees themselves before they accept the position, to start talking about what it really takes to be a trustee and how can we protect those trustees best. And I think most importantly, what the goal of Nomadx is to, because that's all we do is trustee liability in wealth transfer vehicles, is to get to a point where the wealth creators or the grantors can get their first choice of trustee. Because right now, oftentimes, the first choice trustee is first choice because they're well educated and they understand the liability and are very reluctant to take that role. But if we can protect them the best way possible, then we can get the best trained trustees to accept the roles willingly.
Okay, and as follow-up comment, this could be a great way to win over new relationships since no one seems to be talking about it.
Yeah, no, I would agree with that, because pretty much every meeting I come out of and we're talking about these different things, and especially we're not trying to sell a product, we're trying to, help with solutions. And from Nomadx perspective, we're happy to be hired just as a consultant to look at the risks, to help you guys educate your clients, or to provide the insurance solutions. And I think if we're working all together to help everybody do better, I think the whole industry will benefit.
Hey, Kevin, this is Richard. I've got another question. Are we still allowed to go past the time?
Go ahead, Richard.
Okay. Judy, I was thinking in terms of a potential assignment. If we are talking to either an existing trustee to replace as a successor trustee, typically if you had to say we had the meeting, we get the trust documents, we get the financials, and we're looking at trying to estimate what a fee might be for the policy, and if we had to put a plug in for the time to seek the coverage part, how long do you typically say this would be a safe turnaround time to get that quote, so we can say, okay, we're ready to sign documents and know that we're getting coverage? For example, you buy the car. If you have an existing car, they will cover your new car for X number of days until they get all the information. And then they give you a new premium amount?
So I'm going to answer that question in two ways. So if it's a new client, new trustee who either hasn't had insurance or is dissatisfied with their insurance program, we ask for 30 days, but we've been able to turn it around more quickly if need be, say 2 weeks. The second question is, you're currently an insured under our program, and you get a new client. We're actually working through the reporting provision for the underwriter, and we're hoping to get a reporting provision that says you get automatic coverage for a new client as long as it doesn't decrease your assets under management by more than 25%. So we're trying to find a balance between having to report every single new client under an umbrella trustee liability program versus making sure the underwriter is protected by huge growth or more complicated stuff. Does that make sense?
Okay. All right. Any other questions floating out there that you'd like to ask Judy right now? Peter says, from an opportunity perspective, which professional groups need this the most?
Oh gosh, I think they all need it. And what I mean by that is, every single professional group we see, if they're willing to accept the role of trustee, they need it. And so if you're really asking, I work for an accounting firm or I work for a law firm and we already have professional liability, I would suggest that most of the policies don't cover the exposure either at all or in its entirety. So if it's an institutional situation where it's a CPA or a law firm, we've actually created a different policy to sit on top of the professional liability of that organization that's specific to trustee liability. But I don't think there's an industry, player that doesn't have the same challenges. Like I said, lawyers are great at the law, but they may not understand the accounting. The accountants are, obviously expert in what has to be done from that perspective, but may not know all the laws and how to approach things. And I've seen challenges from each and every sector.
All right. Well, thank you, Judy. And obviously, everybody has Judy's contact information there on the screen. I don't see any other questions coming in, so we'll wrap this up, and I'll let everybody know the next webinar we will be doing is April 18th. That's 4 tips for exercising a financial power of attorney through disability and dementia. And please join us for our annual conference, May 16th to 17th in Dallas, Texas. Full information, including the agenda, topics, and speakers, is found at trusteealliance.com. Definitely hope to see you there. Thank you again for your time, and this concludes today's webinar.